Good morning, friends. My dear and respected colleagues in legal profession, distinguished senior members of the bar, ladies and gentlemen, the NALSAR episode, which happened day before yesterday, with the circular issued by Bar Council of India Chairman Manan Misra, the controversy erupted because of that circular and which was subsequently discarded and withdrawn. And the Honorable Supreme Court also deprecated the action taken by the Bar Council of India. In the light of these developments, I would like to share my views about the Bar Council of India functioning. My friends, the Bar Council of India is not a personal command center. The BCI is not the chairman. My friends, today I am not merely about to speak about NALSAR. I speak about the independence, dignity, and institutional integrity of the Indian bar. The NALSAR episode has brought before us a fundamental question. Who regulates the regulator? On 13th August 2026, the chairman of the Bar Council of India, Manan Misra, directed the state bar councils not to enroll students who graduated from NALSAR University, Hyderabad in 2026 until further orders, while seeking a report about students allegedly involved in a campaign concerning the participation of the Chief Justice of India in the NALSAR convocation. The direction was extraordinary because it affected entire graduating batch. But later the same day, the BCI Council itself reconsidered the matter and modified the direction and subsequently withdrawn, deciding that all NALSAR 2026 graduates should be permitted to enroll with the State Bar Council of their choice because the vast majority of the students were innocent. I welcome that withdrawal and correction, but I believe that the bar, we as a bar, must ask a deeper question. How did such a blanket direction arise in the first place? Let me be legally very precise, my friends. I do not want to make an argument that is legally vulnerable. Some may say state bar councils are completely autonomous or statutory, they have got statutory powers and the BCI has no power over them. That is not entirely correct. Section 7 subclass G of the Advocates Act gives BCI the general supervision and control over the state bar councils, and Section 48B empowers the Bar Council of India to give directions to a state bar council for a proper and efficient discharge of its function, not like this. Therefore, our argument should be that the BCI has no power, should not be that BCI has no power. Our argument must be that BCI has a statutory power, but that statutory power must be exercised by the competent institution for the statutory purpose through lawful procedure and not as a personal power. That is the heart of the matter, my friends. My friends, BCI is a statutory institution created by the Parliament. The chairman is an office holder within the institution. The chairman is not the BCI. This distinction may sound obvious, but it is fundamental. The BCI rules themselves provide that the chairman exercises general control and supervision over the affairs of the council subject to the resolutions of the council. Therefore, when an order affects the professional future of hundreds of young law graduates, we have every right to ask, was there a resolution of the BCI council? Was there a resolution of the competent committee? Was there a valid delegation of power? What provision of the Advocates Act was invoked? What was the statutory purpose? These questions are not disrespectful. They are the questions of a lawyer. My friends, Section 6 of the Advocates Act gives the State Bar Council important statutory functions, including admitting, enrolling persons as advocates on their rolls. Section 24, 25, and 26 provides the statutory framework governing the qualifications, applications, and the disposal of the applications for enrollment. Therefore, before denying enrollment, one must ask, what is the statutory disqualification? If a particular person does not satisfy the requirements of Section 24, the law can deal with that person. If a particular person commits professional misconduct, the appropriate disciplinary mechanism exists. If a criminal offense is committed, criminal law exists. But where is the statutory authority for collectively withholding the enrollment of entire graduating batch because some students participated in a campaign against the Chief Justice of India. This is nothing but a sycophantic order. That is the issue, my friends. Then Section 48B is not a blank check for BCI. Let us be very clear about Section 48B. It gives BCI power to issue directions, but the statutory language connects that power to the proper and efficient discharge of the functions of the State Bar Council or its committee. It cannot reasonably be treated as an unlimited personal power to punish the students for expressing an opinion. A statutory power must remain within its statutory purpose. Power must be traceable to the law, and the greater the consequence, the greater the obligation to act carefully, rationally, and fairly. My friends, now let us come to the constitutional dimension. The controversy reportedly concerned opposition by some students to the participation of the Chief Justice of India in the NALSAR convocation in view of his comments against CJP and also making some comments against the protest of the students. We may agree with those students. We may disagree with them, but one principle must remain very clear. Disagreement is not automatically misconduct. Law students do not surrender their constitutional citizenship when they enter a law school. They have a right to think and they have a right to express their opinion. They have the right to protest. They have a right to disagree. Subject, of course, to the constitution and valid law. And the legal profession should be particularly careful here, my friends, because what is a lawyer trained to do? A lawyer is trained to question power. A lawyer is trained to challenge the authority. A lawyer is trained to say, show me the law, show me the evidence, show me the authority, show me the procedure. If we tell law students that disagreement with the authority may jeopardize their professional future, what kind of lawyers are we producing? Are we producing constitutional lawyers or obedient subjects? My friends, let me make another point very clear. I have the highest respect for judiciary. The independence of the judiciary is indispensable to our constitution. The office of the Chief Justice deserves dignity, but respect for the judiciary cannot mean that every action of every judicial office holder becomes immune from criticism. Judicial independence is not judicial infallibility. Respect is not submission, and constitutional democracy cannot survive without the freedom to disagree. My friends, if particular students were responsible for a particular act, let their individual responsibility be examined. But if the authorities themselves are seeking to identify the person who allegedly organized the campaign, then how can an entire graduating batch be treated as responsible? Justice is individual, not collective. The BCI Council's subsequent decision recognized this elementary principle by allowing all NALSAR 2026 graduates to enroll as advocates. That decision is welcome, but we should learn from the episode. My friends, the chairman of Bar Council of India is also a BJP member of Parliament, Rajya Sabha. There is nothing unlawful about a lawyer entering into politics. Many distinguished lawyers have done so. But once a person occupies the office of Bar Council of India chairman, he represents the entire legal profession. He represents the lawyers of every political party. He represents lawyers who support the government. He represents the lawyers who oppose the government. He represents lawyers who are politically neutral. Therefore, the Bar Council of India must remain institutionally neutral, and more so the Bar Council of India chairman is expected to be neutral. The political identity of that particular individual must never become the identity of the institution. My friends, I would also appeal to the state bar councils. I am not suggesting that the state bar council should defy the BCI directions. No, they must comply with the lawful directions issued within the BCI statutory authority, but they must also exercise their own statutory responsibility. When an extraordinary direction affects the professional future of young graduates, they should be entitled to ask, what is the statutory authority of BCI? Who authorized it? What is the statutory purpose? What procedure was followed? And what rights of the affected persons are involved? That is not the insubordination. That is the institutional constitutionalism. And what should the bar demand? I believe the legal profession should insist upon certain basic safeguards. First, no blanket enrollment restriction without clear statutory authority. Second, no collective punishment for alleged individual conduct. Third, no adverse professional action without appropriate procedural safeguards. Fourth, extraordinary directions must disclose their legal and institutional basis. Fifth, political considerations must never determine the professional enrollment. More particularly, and more particularly our legal profession. And finally, the BCI must be governed by its council and its statutory framework, not by the personality of whoever occupies the chair. My friends, the BCI is not an ordinary association. It regulates the profession whose members stand between the individual and arbitrary power. We defend citizens, we defend liberty, we defend due process, we defend constitutional rights. Therefore, the institution that regulates us must itself demonstrate the values that we defend in the court. Let us not personalize this debate. Let us defend the institution. Let us say respectively but firmly, the chairman is not the BCI. The BCI is not the chairman. And the BCI is not the Above Advocates Act. State bar councils are not personal administrative extensions of the chairman of the Bar Council of India. Law students are not their subjects. Dissent is not disqualification. Criticism is not misconduct. Enrollment cannot become a test of political loyalty. The BCI must have power, but that power must remain lawful, institutional, accountable, and professionally neutral. Because if the bar loses its independence, the justice system itself becomes weaker. Therefore, let us preserve the dignity of Bar Council of India by preserving the rule of law within the BCI. Let us remember, no individual is bigger than the institution, whatever the party he may belong to. No institution is bigger than law. And let the Bar Council of India remain what Parliament, the Act intended it to be, a council governed by law, not a command center governed by one personality. My friends, there is an important development which makes this discussion even more significant. Today, the Supreme Court itself questioned the BCI intervention in the NALSAR matter. The CJI Suryakan himself made it clear that the students have right to peacefully protest and asked in substance why the BCI has intervened in a matter which was essentially a dialogue between him and the students. But the most important question came from Justice Bagchi. Was BCI convened to take a resolution like that? We want to know. That question goes to the heart of our entire discussion. Was it a decision of the Bar Council of India as a statutory institution taken through its competent body, or was it an action emanating from a person that is only the chairman of Bar Council of India? The Supreme Court has now directed that no punitive action be taken by BCI or any other Bar Council against NALSAR students or faculty in relation to the incidents referred in the chairman's letters. So the CJI even went further. He told the NALSAR students in substance to obtain their enrollment at the earliest and even invited them to join in the Supreme Court bar. What is the message? What a powerful message. Do not punish young lawyers for peaceful dissent. Empower them to serve the law. My colleagues, it is the culture we should want for the Indian bar. So the Supreme Court intervention therefore reinforces the proposition with which I began. BCI is an institution, not an individual. The chairman is not the Bar Council of India, and professional regulatory power cannot become professional punitive power. And therefore, my friends, my appeal to all of the members is that because this is not the disrespect to the BCI, my friends, as professional lawyers, we must uphold the dignity, the independence of the legal profession, and the Bar Council of India and the state bar councils represents our interests and not personal interests of any individual. Once you are elected to a particular post in the state bar councils, you must remain neutral of any political feelings. So I take this opportunity for to thank all of you. Thank you very much.